Good evening, good morning, good afternoon. This is a global event. So greeting to everybody who is joining us today. Um, I uh, I want to start on time, but I'm willing to give people another 2 to 3 minutes for other colleagues to join us who may be setting up. Welcome, settle in, grab a cup of coffee, cup of water, glass of water rather, and yeah, we'll start in about 2 minutes. Thank you. That's great. For those who have already joined, you will see that there are several icons at the bottom of your screen. There is a chat option. There is an interpretation option as well, and I will get to that once I've opened the meeting. But in the meantime, I'm very pleased to be welcoming everybody joining. I see we have already several participants. This is going to be an excellent conversation. Let's give colleagues another minute and we can kick off. We have much to discuss, so I won't make you wait for too long. Right.
Maybe Wendy, I should also say
Okay.
in Farsi that there is an interpretation. So I will switch to Dari and to mention that there is interpretation. سلام دوستان، تشکر از اینکه به این وبینار آمدید. میخواستم فقط کوتاه بگویم که این وبینار ترجمه همزمان داره. در پایین صفحه تان یک علامت هست که به صورت دایره و کره زمین هست. روی از اون میتونید کلیک کنید و ترجمه دری و پشتو را همزمان بشنوید. وقتی که روی از او کلیک کنید 3 گزینه میبینید: انگلیسی، دری و پشتو، و هر کدام را که احساس راحتی میکنید میتونید روش کلیک کنید و به همان زبان ترجمه را بشنوید. تشکر.
Fantastic. Thank you. Thank you, Artemis. On that note, I think we can kick off. Colleagues, good morning, good afternoon, good evening. Quickly, my name is Wendy Isaac. I'm greeting you from the streets of Johannesburg, South Africa. I am a human rights lawyer, activist, and presently working with Madre as the Senior Gender Justice and International Law Fellow. And on that note, on behalf of Madre and the Gender Persecution Observatory, it really is my honor it's my honor and privilege actually to open this meeting and to extend a very warm welcome to all of you. And thank you for joining us today for this highly significant discussion on race, gender, and apartheid in the UN Crimes Against Humanity draft treaty. We are gathered today because we do need to deliberate and on critical issues and questions that have arisen and that will continue to arise for as long as this work continues on the question of international criminal law and the definition of apartheid. And we will hear from our esteemed colleagues, Professor Lisa Davis. I'll return to introducing her properly in a moment. On the parameters of international criminal law. She'll touch briefly on jurisprudence from various tribunals and courts, including the International Court of Justice. As you may all be aware, and this is a quick intro here, the International Law Commission, which is a statutory body of the UN system, has been working on doing research, receiving submissions, engaging member states, engaging several UN bodies in its work on developing a new convention, or to get the UN system to adopt a new treaty, a new convention on crimes against humanity. And one of the provisions, one of the crimes that they're looking at is the crime of apartheid, which is the subject of discussion for today. Now, you may all be aware that the General Assembly adopted a resolution in December 2024, and they're kicking off their program of work as UN member states in January 2026 to basically start negotiating and exchanging on the text of these draft articles. Now, what we are going to hear today from Lisa is, and this is really the purpose of this conversation and this webinar, is to hear from Lisa different views, different perspectives on really what is the definition under international criminal law of the crime of apartheid. How is it defined in the draft treaty? How is it defined in other treaties, for instance, the Apartheid Convention itself, the Rome Statute, and what do we need to be thinking about and doing and advocating for to ensure that the new definition a new definition is adopted, which is most protective and most progressive and does not exclude any groups that are targeted in this respect. I'm confident that you will all listen attentively and you will engage robustly in this conversation. So on that note, I want to welcome, first of all, I want to welcome Professor Lisa Davis. She's a professor of law and co-director of the Human Rights and Gender Justice Clinic at CUNY School of Law in New York. She'll talk us through extensively and comprehensively through the international legal framework. And I also hope that you'll engage robustly in the Q&A session that will be moderated by my colleague Artemis, who is the executive director of the Afghanistan LGBT group. On that note, I will conclude, and I sincerely wish all of you the best in your deliberations, and I hope that you will engage meaningfully and substantively on these issues, taking into account that the crime of apartheid has been perpetrated with absolute impunity in various contexts, my own country included, South Africa, our dear neighbor Namibia, and our dear comrades and activists in Palestine are subjected to this crime. I wish you all the best. Professor Lisa Davis, I hand over to you now. Please take us through, and we look forward to hearing from you. Thank you.
Sure. Thank you very much for that introduction, Wendy. Artemis, do you want to just make quick mention that we do have translation available for those who may need it?
Of course. Thank you so much, Wendy, for your welcoming remarks, and thank you, Lisa. So now I've switched to Dari. دوستان عزیزان تشکر از اینکه به این وبینار آمدید. این وبینار ترجمه همزمان داره به زبان فارسی، دری و پشتو. دوستانی که نیاز به ترجمه همزمان دارن میتونن به یک گزینه پایینی صفحهشان هسته که گلوب یا یک کره زمین هسته که رویش نوشته interpretation، روی از او کلیک کنه، سه گزینه میبینه به انگلیسی، دری و پشتو، و به هر زبانی که احساس راحتی میکنن میتونن به او زبان گوش بدن. فقط کافی است که روی او زبان کلیک کنن. مثلا اگر دری میخواید بشنوید، روی دری کلیک کنید و میتوانید اونجا به او زبان ترجمه را بشنوید. و اگر سوالی داشتید میتوانید توی چت باکس که یک Q&A باکس هست میتونید روی از او هم کلیک کنید و سوال خودتون را بپرسید. با تشکر. Over to you, Lisa.
Great. Thank you, Artemis. Okay, I'm just going to do a share screen because if you know me, you know I love a slideshow. All right, so we're talking now about modernizing the definition of the crime of apartheid in the draft Crimes Against Humanity Treaty. And really, why is this important? And it's important particularly for gender justice because new criminal law treaties come by pretty rarely, and they help set the framework for how we address, understand, and explain and identify victims of gender-based crimes. So this new Crimes Against Humanity Treaty, depending on what provisions are in it and how it's defined, it could really help define the scope for how we see victims of conflict. For apartheid, that would include looking at Palestinians, women, girls, LGBTQI persons. So it's a very important opportunity for us to look at how we can modernize outdated law and bring a contemporary understanding to how we address crimes. So just to begin, the draft language in this draft treaty has changed before. In 2018, the treaty copied language on the definition of gender from gender persecution from the Rome Statute. And you all are probably familiar with that definition. It's pretty outdated. I've put a copy of it up here. It's outdated, it's opaque, it's not how we understand gender today, and certainly not how we understand acts of gender persecution. So we ask ourselves, well, how did this happen? Well, it happened because at that point, there had been very little civil society input, and there hadn't been any discussion on gender or gender justice during the years before the formulation of the treaty. And one of the strategies that we use in treaty development is we like to reuse language that we've used from previous treaties because we know we can get state consensus on that language. It's not always a good strategy because then we end up using language that's outdated or old. For example, the definition of gender under the Rome Statute at this point was decades old. So adding it to the Crimes Against Humanity Draft Treaty probably wasn't the best idea. But that's how this happened. The good news is we were able to remove that definition through a robust civil society coalition that I led in collaboration with Madre and Outright and Jessica Stern. And leading this civil society coalition, letting people know that this outdated definition of gender had been adopted into the treaty and calling for its removal worked. And what we found was the International Law Commission, who was in charge of the drafting at that moment, saw this point of view. They really saw this definition as outdated and needing to be removed. So the point is that we can change language in the draft treaty if we work on it. A few years later, after this happened, I was appointed to the court as the special advisor on gender persecution. In that role, I wrote a policy paper on the crime of gender persecution and explained what gender means under a modern understanding under Article 21 of the Rome Statute so that we could finally get gender persecution charges for the first time and recognize women and LGBT victims for the first time in the case of Afghanistan. A few years later, after that work was moved forward, my title changed, and I became the special advisor on gender and other discriminatory crimes. And the idea was to really look at gender crimes at the intersection of other forms of discrimination, race, ethnicity, nationality. How does intersectional discrimination affect victims? And how does it affect our understanding of what we do about crimes? So that led me to look at the crime of apartheid, especially as there's been calls to codify gender apartheid as a crime, which I personally support. So to understand apartheid, to understand what gender apartheid might look like or how it might be charged, we have to understand how the crime of apartheid works. So there are two places where the crime of apartheid is codified: the Rome Statute and the Apartheid Convention, at least under international law. So we're going to take a little look at these definitions and how we understand apartheid, especially if gender apartheid is defined similarly or the same as how apartheid is defined under the Rome Statute now. So let's take a closer look. So if we look at the definition of apartheid under the Rome Statute, this is how it reads: inhumane acts of a character similar to those referred to in paragraph 1, committed in the context of an institutionalized regime of systematic oppression and domination by one racial group over any other racial group or groups, and committed with the intention of maintaining that regime. Well, you know, lawyers love a long sentence. It's one of our trade tactics. So let's just break this down so we can understand it better. If we look at it, we kind of see that there's actually 4 components to this definition. And if we break that down even more into a list, it becomes a little easier for us to deal with. So let's look at component 1, inhumane acts of a character similar to those referred to in paragraph 1. Well, what does that mean? Well, we have to look at paragraph 1 and see what that says. Now, when we look at paragraph 1, we see the list of acts that comprise of crimes against humanity. murder, rape, torture. So if we have these acts, then we could say these acts are acts that comprise of apartheid. But that's what we have to look at, is how these acts are similar to acts that we want to say comprise of inhumane acts for apartheid. Now, let's compare the Rome Statute's definition to the Apartheid Convention from 1973. So we see something a little different. In the Apartheid Convention, we see that it includes measures that deny basic human rights, things like the right to work, right to education, the right to freedom of opinion or expression, or assembly. So these are human rights violations that we see could be included as acts of apartheid. Now, if we look at the Rome Statute, do those human rights violations look similar to those referred in paragraph 1? Because that's the definition under the Rome Statute. It's a little harder to say that they're similar to some of these acts here. But are there two maybe on this list that we might want to explore further to see that they might be similar to? Well, if you guessed persecution and other inhumane acts, then you're thinking the same way that I am. These are two acts of crimes against humanity that we might be able to analogize these human rights violations to. So let's look at their definitions. When we look at other inhumane acts, we see that it's defined as acts that are of similar character intentionally causing great suffering to body or mind. That's a pretty high bar. Now, these arguments have been made. Amnesty International did a great job arguing how, denying education to a young girl, say in Afghanistan, could cause great suffering to her mind in terms of what it means in her relations to other rights she won't be able to access, her future, her be able to live. So we can see that. Part of the problem is, or at least the challenge with other inhumane acts, is that we have to argue that the perpetrator denied the right to education to intentionally cause great suffering. That's what we have to prove as a prosecutor. Can we prove that, say, for an example, if we were looking at the crime of gender apartheid and we were trying to prove that with the Taliban? Can we prove that they intentionally denied education to intentionally cause great suffering to women and girls? Maybe, but it's a higher bar. So then let's look at persecution. Persecution means the intentional and severe deprivation of a fundamental right. Is education a fundamental right? I would definitely say so. Is freedom of assembly, right to work? I would say these are fundamental rights. Could we prove that the Taliban intentionally deprived women and girls and LGBTQI plus persons of these fundamental rights? I think we could prove that. And in fact, we have under the court with the confirmation of charges, at least to say that we should move forward with looking at that. So this is a bit of a lower bar in terms of trying to prove certain fundamental rights are acts of apartheid. So if we were looking at gender apartheid under this definition, we would want to prove these human rights acts, these fundamental rights violations, as acts of persecution. And that would become the foundation for proving apartheid. And this is what we mean when we say we take a cumulative approach to charging. Cumulative is not the same as complementary. We don't say let's charge persecution and apartheid because they're complementary. We say let's charge persecution and apartheid because they're cumulative, because one builds on the other, because this is how you get in fundamental rights violations as inhumane acts of apartheid. Again, we've seen on the list, we have rape, torture, and murder. Those acts can get in on their face. But if we want those human rights violations, it's going to be much easier to bring them in as acts if we prove them as acts of persecution. And this is important because cumulative charging, it's not only a way that we tell the historical record of what happened, the holistic story of what victims faced, it's also how we prove crimes. So I'll give you an example. Can you think of a situation of conflict in the world right now where a perpetrator is starving victims to death? Now, we could charge murder. Of course we would. But if we wanted to prove that murder, how would we prove it? We'd have to prove it by showing the starvation that led to it, because it's different than being killed by a bullet or a bomb. And wouldn't we want to charge that starvation, charge those torturous acts that slowly led to someone's death? Of course we would, because we'd want to tell the holistic story of how people died. But we also need to charge that starvation because we need it as a foundation to prove the murder. We have to prove that that starvation happened and was intentional to lead to the murder. So that's what we mean by cumulative charging. It builds a foundation in law, and it also helps us tell the whole story. Now, could we charge gender apartheid under the Rome Statute? I get this question a lot. I think we'd have a pretty good argument to ask the court to look into doing that if we were able to codify gender apartheid under the Crimes Against Humanity Treaty. Right now, gender apartheid doesn't have a definition. It doesn't have consensus as a crime. These are things we need to work out. Much like we can't charge gender-based violence, because gender-based violence is a term of art. Gender apartheid needs to have more consensus in terms of it being recognized as a crime and recognized with a particular definition. Once we got to that point, I think there would be a pretty good argument to ask the court to charge it as other inhumane acts. But if we did that, and we did charge gender persecution as an inhumane act, we would still have to prove these four components if these four components are the definition of gender apartheid, changing racial groups to gender groups, or a similar definition. So you still have to prove all the components under other inhumane acts if you were to charge this as that under the Rome Statute in theory. So that's why it's important to look at these components and to understand how the crime of apartheid works under the Rome Statute. So let's look at the next two components. I like to look at 2 and 4 together, committed in the context of an institutionalized regime of systemic oppression and domination, and committed with the intent of maintaining that regime, because I feel like they really go together. So if we look at the definition of apartheid under the Rome Statute compared to the Apartheid Convention, we see a difference here. We see a narrowing of the definition of apartheid with this new language that was introduced, institutionalized regime. So what does that mean? Well, if you look back at the Travaux on the Rome Statute, you see is that institutionalized regime was really added at the insistence of the United States. They wanted to raise the bar on how we identified the perpetrator group. And they wanted a perpetrator group that was more organized. Maybe a perpetrator group that's more in authority or control of a region or an area. So it's a little bit of a higher bar than what we had in the Apartheid Convention. But, if we were looking at gender apartheid, could we prove that the Taliban was an institutionalized regime of systematic oppression and really engaging in systematic oppression, gender oppression? I think we could. I think we could definitely make that bar. In fact, we have the foundation for it already. When we brought charges to the ICC and the trial chamber confirmed them, the trial chamber said that gender persecution encompasses not only direct acts of violence, but also systemic and institutionalized forms of harm. This is great news because this helps us build that foundation for gender apartheid charges if we were ever to be able to make that argument of bringing them. So this is good news for us. In fact, Richard Bennett, the special rapporteur in Afghanistan, has found the same thing. He's also said that the Taliban system of institutionalized system of gender oppression and really warns the international community to make sure we're not normalizing what the Taliban does. And I think those are words we really need to heed. So we see this with gender persecution charges in other places too. Gender persecution can be an institutionalized system. Sometimes what I hear is a differentiating between gender persecution and gender apartheid to say that gender persecution fails because it fails to be an institutionalized system, where apartheid could show an institutionalized system. That's not quite accurate under law. So we don't want to say that. Also, this isn't just about adding an extra charge. This is about building a foundation of cumulative charges, like that example I gave with starvation and murder. So building gender persecution and showing that it's an institutionalized system, that would help us with future theoretical gender apartheid charges. Now, let's deal with the last component, component 3, the third one, by one racial group over another racial group or groups. This is the one we'll spend the most time talking about because this is the one that has a little bit of a quagmire in its history of drafting. So to answer this question, we have to look at how protected groups, like racial groups, are understood under international criminal law. Well, just for you non-lawyers out there, how do we look at treaty interpretation? How do we understand statutes and treaties? Well, there's 3 main things that we look at when we're trying to understand a treaty. One is just, what's the treaty say on its face? That's the statutory language. 2 is, what do courts say? What have they said in their jurisprudence about how they interpret that statutory language? And 3 is, what does the travaux say? The travaux is what the drafters thought when they were drafting that treaty. And courts really look at the travaux as well. They really look at the statutory language and the travaux when they're trying to interpret and uphold a treaty. There are some other factors we look at in international criminal law. We look at strict construction of terms. That's because international law carries a higher penalty than human rights law. We look at the principle of legality. That's like looking at defendants' rights. And that's important because international criminal law really is dealing with individual perpetrators, whereas human rights law is often dealing with states. And of course, we look at customary international law. So where are groups, protected groups, codified under international criminal law? Well, it's not surprising that we find them in the 3 big discriminatory crimes: persecution, apartheid, and genocide. Now, under genocide, we see racial, ethnic, national, or religious groups are protected. And we see that in the Rome Statute, the Yugoslavia and Rwanda statutes, and the Genocide Convention, where it really originated. The crime of apartheid, as we said before, is only codified internationally under 2 statutes, the Rome Statute and the Apartheid Convention. And the crime of apartheid is really looking at racial groups. Now, when we look at the crime of persecution, we see something a little different. The crime of persecution is it protects against any identifiable group. There is no list of groups for the crime of persecution. Now, that's true for the Rome Statute, which uses this language on its face to define the crime of persecution. It's also true for the Rwanda and Yugoslavia tribunals, for the Nuremberg tribunals, where they didn't even discuss what a persecutory group looks like. And that's because persecution is more about what the perpetrator thinks and who they were targeting, which is why we use the term grounds. So it is limiting in terms of its grounds, and we know there's 7+ grounds under persecution under the Rome Statute. But that's about intent. That's about what the perpetrator thinks. Groups are about the victims, who's actually targeted. We're going to get into that a little bit later, but I just wanted to flag for you here, this is where we find groups under international criminal law. Now, let's start with the crime of genocide. We know there's 4 protected groups: racial, ethnic, national, and religious. And so let's look at the Travaux for this. So if we're looking at the Travaux for the Genocide Convention, which is really where this comes from, what we see is that the drafters of the Genocide Convention really looked at these groups as immutable characteristics, that they were stable or immutable groups, meaning that it was really hard to change groups if you were a member of one of these groups. So they really took an outdated view to race. I mean, after all, it was the 1940s, and we have a much more sophisticated understanding of race as a social construct now. But back then, we didn't really have a good understanding of race. And we really looked at it as more like hereditary characteristics or biological characteristics. So victims would have to share these characteristics to be a member of the group. And that's called objective criteria under law. So when we talk about objective criteria, that's what we mean. We mean you have to establish that the victim was objectively a member of the group. So for example, if a perpetrator targets Muslims and a Christian is killed, is that Christian a member of the group? No, because that Christian wasn't Muslim. And it doesn't matter necessarily what the perpetrator thought. We can look at what the perpetrator thought in some circumstances, but objectively, that victim wouldn't be a member of the group. Now, jurisprudence-wise, groups are really defined in genocide jurisprudence with some kind of combination of subjective and objective criteria. And what's subjective criteria? That's the perpetrator's intent. That's who the perpetrator subjectively thought was a victim or a member of the group and who they wanted to target. And some courts even take this ensemble approach under genocide, where they're really looking to define a group as falling within the racial, ethnic, national, or religious group. So they're kind of looking at all four groups at the same time when they're defining a protected group. Now, a good example of this is Palestine. When you look at the International Court of Justice, they said that Palestine was a protected group from genocide because Palestinians are a protected group from genocide because Palestinians fall within a racial, ethnic, and national or religious group. What they didn't do is call Palestinians, for example, a racial group. So these are the three things we need to think about when we're thinking about the crime of genocide. Objective criteria, that's that hereditary or biological characteristics, for example, for racial groups, or say for religious groups, you targeted Muslims, you were in fact a Muslim victim. Subjective criteria, that's the perpetrator's perceptions. It's who the perpetrator wanted to target. It doesn't matter if the victim was Muslim or Christian, if the perpetrator thought they were Muslim, if the perpetrator thought they were a member of the group they were targeting, then that's all we look at. And honestly, that's probably the best approach, right? Because aren't we trying to hold accountable that discrimination that drives perpetrators to commit these crimes? So subjective criteria becomes very important that way. The ensemble approach combines subjective and objective criteria by looking at any of the four protected groups to establish a particular group's existence. And that was that example I just gave you of Palestinians. Now, there are four cases that I think under genocide law really show the evolution of understanding groups under genocide. It's the ICTY, ICTR, and the ICJ, the International Court of Justice. So let's just take a quick look at these four cases. So under Akayesu, this was in the Rwanda tribunal. This is our first case on genocide. What we see is that the court really relies on objective criteria. And they talk about how victims need to belong to a group by characteristics found at birth, that groups have to be permanent and stable, and that there's objective criteria required to establish a victim's membership to a group. And they developed this rigid checklist of membership criteria for each of the four groups. For example, to be a member of a racial group, you would have to have some sort of hereditary characteristic. Now, on appeals, the appeals chamber said, Yeah, you do have to have some objective criteria. We agree with that. We're looking at drafters' intent under the Genocide Convention. And they also confirm that there's only 4 protected groups under genocide: national, ethnic, racial, or religious. However, they got rid of this whole checklist idea and kind of moved towards this idea that you can look at subjective and objective criteria under all 4 groups. So we see this move towards the ensemble approach starting to begin. Now, go all the way over to Yugoslavia, the former Yugoslavia now, and let's look at the Jelicic case, which came out about a year later. The Jelicic case says, wait a minute, we just want to look at the subjective criteria. Who did the perpetrator want to attack? Who did the perpetrator want to target as a victim or a member of that group? And they reject this objective criteria approach. They say using objective criteria, that would be scientifically irreproachable. It would be a perilous exercise. And it's more appropriate to look at the perpetrator's point of view. Now, I think most international criminal law scholars would agree with this decision. Don't we want to look at the point of view of the perpetrator and who they wanted to attack? Isn't that what matters? Isn't that what we're trying to uphold, is that discriminatory intent that drives perpetrators to do the actions that they do? So I think that this is a great approach because it's looking at a purely subjective approach, much like persecution does. Unfortunately, then we get to Stadic. And Stadic was a Yugoslavia tribunal case on appeals. So the appeals court in Stadic, they overturn this idea of a purely subjective approach. They say you can use subjective criteria, but you gotta have some objective criteria. They look at Jelicic in other cases, they look at the subjective criteria, and they decide that that's not enough in terms of establishing victims groups as provided under the Genocide Convention. Now, at the same time, there was another case making its way through the International Court of Justice. This was a Bosnia case. And in 2007, the ICJ affirms the same finding. It refers to the Stadic case, and it starts with the premise that all parties essentially agree that international jurisprudence accepts some kind of combination of subjective-objective approach, right? That the court also agrees with this approach. And the question it's really looking at was the question that was posed to it, which is whether or not you could establish a victims group under the subjective-objective approach, whether you could establish a victims group using negative characteristics instead of positive characteristics. So negative characteristics would be things that group members don't have. So the things they don't have in common that make them a group. And the court did a really interesting job looking at the Genocide Convention on this. They looked at the Genocide Convention. They looked at Ralph Lemkin, who is, often coined as the drafter of the charge of genocide. They looked at Nuremberg indictments. They looked at this idea of safeguarding the existence of a quote unquote human group. They analogized to murder and how that's different. We can think of other charges like extermination. How is extermination different from the crime of genocide? So they really look at a deep dive into this and into the Chervaux. And what they decide is that you have to have positive characteristics to identify victims as members of one of the protected groups. It's not the lack of them. So what we end up with in genocide case law is this kind of hodgepodge of cases. And I just want to give a shout out, a thanks to Carola Lingus, a professor who helped create this chart. And what we see is that most genocide cases, they're really using a combination of the subjective and objective approach. Now, there are 2 other approaches that are also used, this objectivized subjective approach and the victim subjective approach. We don't have a lot of time to go into that. But to say, what's the problem with this subjective objective approach for a group like, say, LGBTQI plus persons. If you have to use biological or hereditary criteria to define a group, a gender group, you may very well likely end up with male and female or man and woman as the groups. And who is that going to lead out? It's going to leave out trans people. It's also going to leave out the experiences of other LGBTQI plus persons and the reasons why they're targeted and killed in conflict based on gender discrimination. Now, the victim subjective approach or objectivized subjective approach, they say, well, we could use the victim's perception too. It's not just the perpetrator's perception. But, you know, this doesn't work so well for LGBTQI plus victims in conflict because sometimes their identity is not disclosed. Sometimes their identity is hidden for their own safety. And if, say, for example, a trans victim were to die in conflict based on gender discrimination, their family may not feel comfortable outing them as a trans person. That might risk their safety, or they may not have seen them as a trans person. They may not have even acknowledged their true identity of who they are. Neither may have the perpetrator who uses more derogatory or discriminatory language. So generally, we don't like putting the onus on victims or victim perceptions for this, and it's not the general way courts have approached genocide, but it's still problematic. Now, we don't have a lot of time to talk about that, so I do encourage you to read the law review article that myself and Kirby Anwar wrote, and it goes into this whole conversation, and it talks more about the victim subjective or objectivized subjective approaches. And we're going to record this webinar so you can pause it on this screen if you want to go look up that article and talk more about it and read more about it. I'm also just going to give a few seconds to each of the citations that I use that I just talked about for the genocide cases so that all of you international criminal law nerds out there who, like me, like to see the actual citations of where a presentation comes from, you have them right here. And you can go back and you can pause the webinar, like I said before, if you want to look up these citations and see the passages and the cases that I just referred to. Now, let's turn to the Apartheid Convention. So if we're looking at the definition of apartheid, let's look at how we understand groups under apartheid. So if we look at the Travaux, what we see is that the Apartheid Convention takes its understanding of groups from the Genocide Convention. There's a really robust, rich history in the Travaux discussing this, discussing apartheid as a prelude to genocide, distinguishing the crime of apartheid from the human rights violation of apartheid found under CERD. There's very rich context in this. I don't think this is, I think this is pretty well accepted under international criminal law. In terms of international jurisprudence, well, we don't have any. There haven't been any apartheid cases litigated under international tribunals. So there's none today. I will note there are several domestic cases that are pending in South Africa. And there's been a little bit of a struggle with the definition of racial groups for apartheid that you can find in the accountability mechanisms for Palestine and Myanmar that are also struggling with this same issue of how we define groups. I'm not going to get into that because we don't have a whole lot of time, but again, you can see our article and where we discuss the Travaux and then also where we discuss this struggle under some of the UN accountability mechanisms. So what do we know? We know that the crime of genocide has 4 protected groups and it uses subjective and objective criteria. Now, the crime of apartheid, at least according to the Travaux, also uses subjective and objective criteria, and it only has one group on its face. That's racial groups. So one way that genocide and apartheid are a little different, besides that one has 4 groups and the other has one group, is that apartheid has something else. It actually allows for recognition of victims who are not a part of the racial group. So for example, white opponents of apartheid in South Africa still could be considered victims of apartheid if they were direct victims of the inhumane acts that were used to maintain that regime, even if they're not counted as part of the protected group. So what does that mean if we apply that to gender apartheid? Well, we'd still see an exclusion of LGBTQI plus persons from members of the recognized group. Because if we use that subjective objective criteria, we're likely going to end up with male and female categories, and we know what implications that's going to have on our community. Now, I have heard some argue that this is okay because LGBTQI plus persons can still be recognized as victims of inhumane acts, even if they're not recognized as members of the protected gender group. And I have to tell you, this is very problematic because overall, first, it risks excluding LGBTQI plus persons from recognition as victims of the discriminatory regime itself. That means risk losing them as victims of gender oppression, losing that homophobia or transphobia as part of the gender oppression. But also, it would really reinforce these harmful tropes that equate gender with biological sex. And those tropes are still very well and alive and out there in different right-wing and fundamentalist communities. We see these raised all the time. It would also exclude trans persons. We run this risk of excluding trans person from recognition as men and women, as their true selves. And of course, it would marginalize the experience of LGBTQI plus persons within systems of gender oppression. And it fails to capture the full scope of perpetrators' discriminatory intent. It would limit accountability. It would limit the historical memory. But let me just give you an example so you understand what I mean. If a perpetrator kicks in the door of a home of a husband and wife and says, your wife is not in dress code compliance, they're not wearing their hijab the correct way, and that perpetrator beats that man or beats that woman, we would recognize these as inhumane acts, of course. Now, let's say the perpetrator kicks in the door of the next house and sees two women living together and views them as lesbians and says, you can't live this way, and kills one and rapes and enslaves or forcibly marries the other woman. Now, we may get those other acts, those other inhumane acts of murder or rape, but what we're not going to get is why. And in that situation, those women weren't just targeted because they were women. They were also targeted because they were either lesbians or perceived as lesbians. And we have to capture that if we're going to tell the whole story of what happens in conflict. Otherwise, to erase that, we start to reinforce, inadvertently reinforce, homophobic and transphobic tropes and misogyny. So we see cases of gender oppression happening that we would characterize as gender apartheid happening in Afghanistan under the Taliban regime. And these acts are happening to both women and girls and to LGBTQI plus persons. And again, if we have to look at the group from an objective and subjective criteria, and the group becomes women, we could risk exclusion of LGBTQI plus people. The better way to approach apartheid groups would be subjectively. Then all gender groups, meaning all groups targeted on the basis of gender, would be recognized, and then we would have a broader inclusion of victims. And this also has implications for the outdated definition of apartheid as it exists now in the Rome Statute and has been adopted verbatim into the draft Crimes Against Humanity Treaty. Because this definition has also sometimes been used as an excuse to exclude Palestinians from counting as a racial group. And that could further entrench the invisibility of Palestinians as victims of apartheid. So what do we know? Well, we know the crimes of genocide and apartheid, that racial group or groups is likely determined by subjective and objective criteria. That's that combination of the perpetrator's perception and something more biologically based, like hereditary characteristics. The crime of persecution, on the other hand, that targeted groups based, that can include any identifiable group. So there is no list of groups under persecution. And it doesn't require any sort of biological or hereditary membership proof for gender or race, or victims targeted based on gender or their gender or race. So we don't need that under persecution. It's purely the subjective approach that we use. So if we look at Article 6 under the Rome Statute, we see the language under genocide says that it's about national, ethnical, that's the language we use, national, ethnical, racial, or religious groups. Under apartheid, it's only racial groups. And under persecution, it's against any identifiable group based on 7+ grounds. This is the language on the face of the Rome Statute. So let's take a closer look at persecution against any identifiable group. What we find is that persecution can happen against any identifiable group. We can define the group as we wish, but we have to base it on how the perpetrator perceived the victims. And the way that the perpetrator perceived the victims has to be based on a discriminatory intent based on either one of the 7+ grounds, including gender. What it does not say on the face of the Rome Statute is that persecution has to be committed against a political, racial, national, ethnic, cultural, religious, or gender group. It does not say that. And that difference is intentional, and it has meaning under international criminal law. In fact, if we look at all of the statutes that codify genocide, apartheid, or persecution, we see the same thing. We see this same language of racial, ethnic, national, or religious groups under the Rome Statute, the ICTY, ICTR, the Genocide Convention. We see racial groups under the 2 statutes that we have in international law that codify apartheid as a crime, the Rome Statute and Apartheid Convention. And then the crime of persecution we see in the Rome Statute, any identifiable group. We don't even see a definition of a persecutory group at all in the ICTY, ICTR, or Nuremberg on the face of the statute under persecution. So let's take a little bit closer look real quick at persecution. Now I'm looking at a different document. I'm looking at the elements of the crimes. And this is kind of like a compendium to the Rome Statute. And it helps us understand how to charge crimes like persecution. Now, under the elements of the crimes, there are 6 elements for persecution. I only have 3 up here that are the most relevant. I kept in element 1 because it's to go back to what we were talking about earlier, about how the perpetrator severely deprived a victim of a fundamental right. So that's what we were talking about before. And it's very nice in the terms of the way it can bring human rights violations into international criminal law. Element 2 is really talking about the group, that the perpetrator targeted such persons or persons by the reason or identity of the group. And then element 3 is talking about perpetrator intent, that targeting that the perpetrator did had to be based on one of these 7+ categories. Now, if we take a closer look at element 2, which is groups, we actually see something interesting. We see 2 different ways that we could identify the group. First is by the reason of the identity of the group or collectivity. Well, what does that mean? Well, that means we look at a group as subjectively defined. The group could be women, or women and girls and LGBTQI plus persons, or women and girls and LGBTQI plus persons and advocates of women and girls' rights. Whereas the second part, and this is an option, right? Because it uses the word or, we can use either or. The second is, or targeted the group or collectivity as such. This we would use to define a group is subjective and objective criteria. So here's a question for you. If we have option 1, which we can use subjective criteria, which is easier and a lower bar, why even include option 2? And I think the answer is twofold. There are 2 benefits to having both of these options, even though we probably use one in most cases, persecution. The reason is, one, it closes the loophole on perpetrators escaping liability. It helps us with that. And second, it gives us a way to bring in evidence to build that foundation for who's a member of a group for apartheid and for genocide, because it's mirroring that language, so that you can't argue that a group that's targeted by a perpetrator for persecution is a different group than a group that's targeted for persecution, targeted for an inhumane act for apartheid, or part of a genocide group. So it helps us again with that idea of cumulative charging. Now, what's the problem with the definition of apartheid? Well, there's only one group. It's racial. So like we were talking about before, that is going to exclude women, girls, and LGBTQI plus people. It's also limiting us in terms of how we identify racial groups, because we can't use the ensemble approach that they use under genocide. We don't have that option because there aren't more than one group. There isn't more than one group under apartheid. So what's at stake here? Well, at stake is whether or not we would be able to get recognition of conditions that look like apartheid, namely gender apartheid, for Afghan women and girls and LGBTQI plus persons, as well as for apartheid based on racial discrimination for Palestinians, and for all South Africans and Namibians who experienced apartheid at intersectional oppression. So experiencing what we would call gender apartheid and racial apartheid, especially for Black women and LGBTQI plus South Africans and Namibians. So what I really want you to walk away with is that victims recognition depends largely on how we define apartheid as a crime. We got to get this right in the Crimes Against Humanity Draft Treaty, because there's a lot at stake. So one of the things we know at stake is what I was just talking about. It's intersectional apartheid. We know that there are documented cases of apartheid based on both racial and gender oppression that affected South African and Namibian Black women and LGBTQI plus persons, that they endured overlapping systems of racist and gendered oppression. I learned about these stories when I went to South Africa to discuss gender apartheid back in June, and that there's been very little mention, visibility, or redress for the intersectional approach to these crimes. And we also know that there's a system of gender apartheid happening in Afghanistan, and there's a proposal to codify gender apartheid as a crime in the Crimes Against Humanity Treaty. So if we're looking at the definition of apartheid in the Crimes Against Humanity Treaty, right now it looks exactly like the definition under the Rome Statute. It's the exact same language that we've been talking about. Now, if we were to change this or add gender apartheid, what would that look like? Well, one proposal would be to change racial groups to gender groups, so that we would have the same definition, but we're just exchanging race for gender. So if we do that, we're going to have the same problems ahead of us when we try to charge gender apartheid. We may run into the same challenges that we've seen before with the definition of groups. And if we have to base gender on or define gender groups based on heredity or immutable characteristics, we're going to end up excluding LGBTQI plus victims. We're also going to continue the invisibility and risk excluding Palestinians from recognition of apartheid based on racial groups. All right, so that's basically my presentation. I just want to give you a a few answers to a couple of questions that I often receive when I give this presentation, because they're very, very common. So 3 questions that I often get when I'm talking about the proposals for gender apartheid definitions. One is, doesn't the Rome Statute follow a contemporary understanding of gender under persecution? I mean, would this really be a problem for gender groups under apartheid? I get, well, Lisa, didn't you write the persecution policy on the policy for the Office of the Prosecutor on the crime of gender persecution? Well, I did. I did write that policy. The thing is, with persecution, again, we're talking about the group. We're not talking about intent. Gender grounds is about the intent of the perpetrator. And in the Rome Statute, we have a limited understanding of perpetrator intent. It is limited to the definition that you see on this screen. It refers to the 2 sexes within the context of society. So my policy paper that I drafted, it really goes through how we understand gender from the perception of the perpetrator and how we understand it under modern day. And the reason why I can look at modern day with gender persecution is because we have Article 21 in the Rome Statute, which allows us to look at human rights treaties evolution on the definition of gender. And if you look at the policy paper closely, you'll see what I talk about. I actually break down these 6 elements under gender persecution. And I talk about the perpetrator's discriminatory intent, how it's looking at maleness and femaleness, that's what we mean by this definition in the Rome Statute, that it could intersect with other grounds of persecution, that it's about how the perpetrator perceives the targeted group, that the perpetrator could perceive a gay man or a lesbian as being a part of the group, or they may not really be gay or lesbian, that it doesn't matter. It's about how the perpetrator perceives them. It talks about how we include intersex, non-binary, and transgender person under this definition, because it doesn't matter if the perpetrator doesn't see them as belonging to the quote unquote male and female groups that they may be targeting, because it's about the perpetrator targeting them with that discriminatory intent, that intent to discriminate based on gender. So if you look through the policy paper, you'll see some of these different passages and categories, and I've noted some of the more relevant paragraphs here, and would encourage you to go back and look at that. So in that way, it's different than what we're looking at with the crime of apartheid. The second question I get is, well, what about human rights law? Human rights law's understanding of race and gender is more contemporary. We see these terms as social constructs. We absolutely do. And it's a really good question, because discrimination is the foundation for crimes of persecution, apartheid, and genocide. And when you look at the CERD Treaty, you see that racial discrimination is defined pretty broadly, and it really implies that it's based on a social construct. And CEDAW does the same thing for gender. The problem is we can't use human rights law for international criminal law, because we have this requirement to strictly construe crimes. It's based on the principle of legality. It's about defendants' rights. So because of this principle of legality that I was explaining before, we can't really bring it in. It can be there as something we look to, but it's not something that we can use to change interpretations of law, unfortunately, unless there's something in a treaty that allows for that. And this was also discussed during the Apartheid Convention drafting, this whole idea. And I encourage you again to go back and read our law review article for more discussion on that. Well, what does that mean for the Rome Statute? Well, we have Article 21. Article 21 in the Rome Statute says we can look at international human rights law. You got to have that provision in your international criminal law treaty in order to make it binding. So Article 21 says you have to look at the principles of international law. And in failing that, then you can look at the laws that are derived from national law. But even with that, it says that even if you're doing that, you still have to look at the principles of human rights law. You still have to interpret national law within internationally recognized human rights principles. It still has to be consistent with that. So Article 21 is really strong, and it gives us a way to look at the Rome Statute through the eyes of human rights law, evolution on some of these terms. The problem with the Crimes Against Humanity draft treaty is there is no Article 21. We don't have this in the treaty. And I would encourage civil society and members who are advocating or working on this treaty to call for Article 21 to be added into the Crimes Against Humanity treaty. It shouldn't have been left out, and it would do a great service to still be in there. Now, one thing I just wanted to flag quick, because this happened in 2021, was the Qatar v. UAE case. And this was an International Court of Justice case. And it was a case looking at racial discrimination and the definition of racial discrimination understood. And basically what the International Court of Justice said is, well, when you're establishing discrimination, racial discrimination under the definition of CERD, looking at race, color, descent, or national ethnic origin, that these categories, they also require characteristics that are inherent at birth. This is taking a step back. It is taking a step back. And for all of you international criminal law and human rights law nerds, please take a look at this case, because it's not good that the International Court of Justice is encroaching on human rights law and on CERD's interpretation this way. Now, I do have some of the key paragraphs you can look at. Paragraph 86 gives me some hope that there's some wiggle room around what the court is doing, but it's still a problematic case. So, question 3. Well, what about the International Court of Justice? Didn't they find apartheid in the Palestine situation? Well, actually, there were 2 Palestine cases, so let's just look at each of them very quickly. There was South Africa v. Israel, which South Africa championed, looking at the obligation to prevent genocide happening in the Palestinian occupied territories. And while the court doesn't define Palestinians as a racial group, they do apply this ensemble approach where they look at Palestinians and say, well, they qualify as a group under racial, ethnic, national, and religious groups under genocide. So a clever way to be able to get Palestinian recognition. The advisory opinion, that was the opinion filed in 2024 for asking the court for an advisory opinion on the situation in Palestine. And in that case, the court finds that there is apartheid as a human rights violation, but it's silent on apartheid as a crime, despite over 24 states giving submissions to the court calling for the recognition of apartheid as a crime happening in the occupied territories, and for recognition of apartheid as the prohibition of apartheid as a peremptory norm. But even despite this, the court doesn't go that far. It only finds that apartheid is a human rights violation. But remember, we have this previous bad case law that we talked about. That's probably also informing the court on this decision. So last question. Well, what does it matter if we modernize the definition of apartheid in the Crimes Against Humanity Treaty? I mean, how is this going to help Afghans or Palestinians? Isn't it going to be years before the Crimes Against Humanity Treaty enters into force? And can civil society really change a draft treaty? So I want you to think about those questions as we go through the next couple of slides. First, the definition of apartheid can change. It can change in the Crimes Against Humanity Treaty because of 2 reasons. One is the Crimes Against Humanity Treaty has changed before. Remember, we did it in 2019 when we got the outdated definition of gender under gender persecution removed. Secondly, the definition of apartheid has changed before. It changed from the Apartheid Convention when it got adopted into the Rome Statute. So it definitely can change. Now, there have been a few proposed definitions of gender apartheid. In 2023, the proposed definition from a UN body was basically looking at the same definition of apartheid that's in the Crimes Against Humanity Treaty. It's the same one from the Rome Statute, and basically exchanging race for gender. Now, this is a good place to start, right? You want to start with the language that you have for a crime, like the crime of apartheid, and you want to see how you can revise it so that it's broader and it gets you what you want. So this was a good place to start. It's a normal place to start. But we can't stop here because this risks exclusion of LGBTQI plus groups and also the definition of apartheid that codifies discrimination against racial groups, would continue to be a threat for recognition of Palestinians. So we can't stop there. And we didn't. In 2024, the UN Working Group on Discrimination Against Women and Girls proposed a slightly different definition. They changed it to one group over another group based on gender. This is the language from persecution. This would solve our problem. This would make sure we don't have to worry about objective criteria. We could just look at the perpetrator's perception. And isn't that what we want to uphold in accountability? I mean, isn't that what we want? So if you apply this definition the working group came up with to the definition of apartheid that's been proposed in the Crimes Against Humanity Treaty, what you have is one group over another group of groups based on race or gender. And for those of you who are not international criminal law experts, the word "or" here means that you could charge apartheid or inhumane acts of apartheid as either based on race or gender or on both. You could look at it from an intersectional approach. It allows us to do that. So going back to that question of why do we care? Is this really going to help Palestinians or Afghans or anyone else? Because the treaty isn't going to be retroactive. It's going to take years to codify. Who knows which states or authorities will sign it? So why bother to revise the definition of apartheid? Well, one is we care about building customary international law, especially under criminal law, because we have very few options and opportunities to build international criminal law because it's very slow moving. The second, we could support future charges at the ICC. And third, we could support calls for reparations. So in terms of future charges, we have Article 21. Can we charge apartheid in the Palestinian context? Yes, we can, because we have Article 21. And if we have states mobilizing to understand apartheid as based on race and based on gender, then that would only support the court to be able to look at future apartheid prosecutions. There's also reparations for Palestinian victims. Now, this is real important because there isn't a clock on reparations. So genocide accountability, we know that there have been reports concluding that there's genocide acts that are happening in the occupied territories, most recently from the UN. But genocide accountability for Palestinians is likely to be limited to more recent acts, such as those committed since October 2023. What about Palestinian victims that were victims before October 2023? How do you bring them into a reparations conversation? The way you could bring them into a reparations conversation is by recognizing them as victims of apartheid. It's harder if you're using individual crimes like rape or torture or murder because those apply to individual victims. But apartheid is a system of oppression, right? And that would bring in thousands of more victims for a reparative justice conversation. So apartheid accountability and recognition in the Palestinian context is incredibly important. It would also help us acknowledge intersectional apartheid in places like South Africa and Namibia. It would visibilize those experiences of Black South African and Namibian women and LGBTQI plus victims who lived under racial and gender apartheid conditions. Victims who have often been invisibilized in terms of this intersectional experience. And just a quick note on essentialism and intersectionality, because that's really what's at risk here. You know, when I was in South Africa back in June, I heard South African advocates express strong solidarity with Afghan women resisting Taliban oppression. But they also cautioned that adding gender apartheid as a distinct crime to the Crimes Against Humanity Treaty without acknowledging apartheid's gender impact on South Africa could sideline that unresolved legacy. We don't, in other words, we don't want to essentialize the experience of gender apartheid just to Afghanistan. Just as we don't want to essentialize the experience of apartheid based on racial oppression to the experience of South Africa. We need to remember to look at intersectionality. And there are factors that contribute to essentialism that we have to be cognizant about. So what about two definitions of apartheid for under the Crimes Against Humanity Treaty? This is one proposal that we have two. We have one that's gender apartheid, and the other that's just apartheid. It would be covering racial groups. What's the problem with this? Well, if we do this, the term apartheid could become conceptually fragmented. You really don't want to have two different crimes that are the same but slightly different, because you could develop different bodies of case law, separate bodies of case law, and that could potentially lead to inconsistent standards. It could mean that courts apply different thresholds of severity. You know, it could undermine the coherence in international criminal law. And, you know, most importantly, you're not going to get intersectionality. You're not going to get those intersectional crime conditions of apartheid based on race and gender like we see in South Africa. So it's better just to have one definition for apartheid, and having a definition that recognizes oppression based on race or gender. I mean, what would be even better is just end it at group or groups and don't even mention what it's based on. Then it could be based on anything. Might be a hard call to get into the Crimes Against Humanity Treaty, but at least we could talk about it. And if not, at least we could include based on race and gender, building off the UN Working Group on Discrimination Against Women and Girls definition, and making sure that it's inclusive of all victims in those categories. Now, there's two options that I've seen for having one definition of apartheid. One is just kind of repeating the same groups again. The other one was the one I just talked about. So what's the problem with this repeating the same groups again? Saying by one racial group over any other racial group or groups, or by one gender group over any other gender or gender groups. What's the problem with that? Well, the problem is that would risk exclusion of LGBTQI plus persons under gender, right? It also doesn't solve our problem of racial groups for Palestinians either. But we still have this same problem of using the group language. The second problem that this definition runs is the exclusion of intersectionality. How do you charge intersectional conditions of apartheid under this definition? It's very challenging. And that would exclude the experiences of Black South African and Namibian women and LGBTQI plus persons in terms of what they've been calling for and what they've articulated that they have experienced. That's why we need a definition that is inclusive of everyone and is inclusive of an intersectional approach. So our recommendations have been is that we've got to include apartheid, change the definition of apartheid, modernize it, have it included based on race and gender in the Crimes Against Humanity Treaty, utilizing that language that the working group provided us. But secondly, we have to support civil society. We need South African, Namibian, Afghan, Palestinian civil society voices in this drafting process, as well as women and girls and LGBTQI plus persons and other marginalized groups, so that we ensure that the treaty is building on, rather than sidelining, the full legacy of the anti-apartheid struggle. Now, there's some more sources you can go to if you want to read more about this issue. Again, we're going to record this webinar so you can pause it on this slide and see. And if you're interested to learn more about how the draft treaty has changed before, how we did it in 2019 when we led that civil society initiative to remove the outdated definition of gender, I threw up a couple of resources where you could read more about that as well. And on that, I'm going to stop, and I'm going to stop sharing my screen. Whew, that was a long presentation. I hope it was all understandable. So over to you, Artemis.
Uh, Thank you so much. Thank you so much, Lisa. And I really appreciate it. Thank you for your very comprehensive and I think deeply thoughtful, provoking presentation, Lisa. I think you've clearly shown how the current definition of apartheid in the Draft Crime Against Humanity Treaty risks excluding so many victims and so many people. And I think not only those facing racial apartheid, such as Palestinians, but also those living under gender apartheid, such as Afghan women and girls and LGBTIQ people in Afghanistan under the Taliban's rule. And Lisa, as you also highlighted that the ICC trial chamber recently recognized that gender persecution in Afghanistan involves not only acts of violence, but also systematic institutionalized forms of harm. And also, as you also mentioned, that the UN Special Rapporteur on Afghanistan has warned against normalizing the Taliban's regime of institutionalized gender persecution. And Lisa, I think these examples reminds us that revising or modernizing the apartheid definition is not just it's not just a technical issue. I think it's about ensuring that the law reflects the lived realities of those enduring these crimes today. But Lisa, I have a specific question for you. Some people argue that revising the apartheid definition, particularly by adding the phrase based on to expand the recognition, could complicate the negotiations, or some people argue that it can confuse its member states and it will reduce the likelihood of the treaty's adoption by the member states. I want to ask you, how would you respond to this concern, Lisa? But before answering Lisa, I want to also ask the audience to write their questions or comments in the Q&A box. And after writing your questions, I will read it for the speakers and they can answer it. Over to you, Lisa.
Okay, thanks, Artemis. Well, I have two thoughts on that. One is that states are pretty smart. They're not easily confused per se, and they have a lot of experience working on treaties and negotiating treaties that are both bilateral and multilateral, so meaning with each other and with other groups of states. So I wouldn't downplay a state's ability to understand the language of the treaty and what we're talking about. They often have a lot of experts that work on this stuff. The second thing I would say in terms of like, the more we tinker with the language of the treaty, the harder it is to get passed. Well, that's true. I mean, that's what we're doing when we propose to add gender to apartheid as a protected group. When we do that, we're tinkering with the language, and gender is usually the elephant in the room. It's a stigmatized word. We still have a very uphill battle for gender justice. But why is it important to do that? It's important to do that because we want to be able to recognize what gender apartheid looks like as a codified crime. And changing the language to based on, what that does is allow for a broader inclusion of victims into recognition of those acts or those crimes. Because what we don't want to do is perpetuate bad law. I'd rather see no treaty than a treaty that perpetuates bad law. And hopefully, we can get a more modern treaty that actually expands those categories. Now, in terms of that language based on those magic words, I will say I did get one comment from an attendee who happens to have my cell phone, so I happened to look down at her text. And she recommends that we add grounds, other grounds, instead of based on. And you know what? I totally agree with her. This is Maxine Marcus. She's an international criminal law expert. So I use based on in my slides and in my talking points because it's often just easier for an audience to understand. But using on the grounds of, race or gender instead of based on works just as well. In fact, it's probably better because that's the actual statutory language on the Rome Statute's face for persecution. So just a shout out to Max for making that point.
Thank you, Lisa, for your very clear answer. So now we'll open the floor for questions from the audience. Please feel free to use the Q&A box in the bottom and share your questions, and then I will read them out for our speakers. Okay, I think we have several questions. Maybe I can ask them. I can start with the question from an anonymous attendee. So there is a question that the advocacy for including gender in the definition of apartheid often relies heavily on examples from Afghanistan and Iran. Does this focus risks politicizing the issue or singling out specific countries without political context rather than taking a universal approach to advancing this important treaty? Over to you, Lisa or
Well,
Wendy.
that's a great question. I actually couldn't agree more. Yes, it does. It speaks to that problem I was talking about in terms of essentializing the crime of apartheid, the crime of gender apartheid. Look, we do this. It's just kind of what we do as an international community or as human beings when we try to compartmentalize things. So we like to come up with contextual terms, and there's an advantage to that, because it helps us understand a situation, but there's a disadvantage in terms of essentializing a situation. So what do I mean? I mean, when we look at femicides in Latin America, when we look at honor killings in Iraq, what do we see? We see crimes that are very similar, but they have different contextual names for the region that they happen in. And what happens sometimes with that is this otherizing. But those are crimes that happen over there. Those aren't crimes that happen here. When really, when you look at them as crimes or as elements, it's the same thing. It's based on the same type of misogyny or discrimination that we often see. And that's the same problem we don't want to have with gender apartheid. We want gender apartheid to be a universal crime. We don't want it just to apply to Afghanistan or to Iran. We want it to apply to South Africa and what happened there too. And it was the same risk that we run with apartheid as it is now, as based on race, because in the last, many years, and including when we looked at codifying apartheid in the Rome Statute, there was some pushback from states about whether or not to include apartheid, because there was a little bit of this essentializing of, well, that's what happened in South Africa. That's not going to happen again. We don't like this kind of essentializing. Crimes are universal. They need to be charged everywhere. And that's the difference between a context idea like the Holocaust, perhaps being the term we use for what happened in World War II, and genocide being the crime that we recognize in World War II. Genocide has been charged in other places. Apartheid needs to be charged in other places too.
Thank you so much, Lisa. So we have another question from Melissa. So it's a comment and also a question. So Melissa asked that, first, thank you so much, Lisa, for such a detailed presentation and explanation of the legal issues at hand. There are currently several campaigns underway for the recognition of gender apartheid. Can you please comment on whether these are aligned or not? And if there are concerns about some of these campaigns potentially undermining the efforts to secure the more inclusive definition possible. Over to you, Lisa.
Well, I think what all campaigns looking to codify gender apartheid as a crime have in common is we all want to see gender apartheid as a crime. And that's really important to remember because we are one movement in that way. And sometimes we'll have disagreements within a movement. And those disagreements may be based on political calculations of what we think we can gain in a moment and who we might need to leave behind in order to try and move ahead. Or they might just be, legal disagreements by scholars or academics who may argue that, different definitions mean different things or, have different meanings. So these are things that often happen in movement building around any kind of push for social justice and redress. And I think what's important is that we need to take these different movements, the movement for recognition of apartheid in Palestine, the movement for redress for what happened to Black South African and Namibian women in South Africa, the movement for redress for Afghan women, girls, and LGBTQI plus persons in Afghanistan, and bring them all together. Let's all get together and let's talk this out and let's be a unified force behind one idea, one definition, one civil society push that includes all victims. And I think we can do it because we've done it before and we can do it again.
Thank you, Lisa. We have several questions actually, so I will start with another question. I don't know. I know that we are a little bit over time, but I think this is a very good space for dialogue and discussion and exchange and learn from each other. So maybe we can wait 10 more minutes to answer all of those questions, if it's okay for you, Lisa and Wendy. So we have a question by Catherine Allen. So Catherine said, thank you so much thank you for your really interesting presentation. Lots to think about. I'm wondering what the role of civil society is in making sure that we can expand and improve definitions of apartheid. Should efforts to be focused on advocacy to the UN member states, or is raising awareness, public consciousness also needed in this space? I would imagine maybe both approaches are needed, but I'm wondering how to reduce the potential of pushback, especially considering the current rhetoric against gender rights on the global scale. Over to you, Lisa.
Well, that's a big question. Yeah, I mean, look, fighting for gender justice has always been an uphill battle, but our feminist foremothers have done such incredible work. If they were able to get gender persecution into the Rome Statute back in the late 90s, before we had internet and communication systems the way we have it today, then I think that we should be able to win the gender apartheid codification campaign as well. And yeah, there's different ways we need to move this campaign forward. We have to talk to states. We have to talk to other key stakeholders. We have to engage with civil society so that they push their states. And we have to see where there's key points of negotiation. For example, I think states that support the codification of gender apartheid would have no problems including LGBTQI plus persons in that understanding, because that usually goes along with states who support gender justice. I think states that may be a little bit less warm on gender justice, some of those states are going to have a common interest of supporting Palestine and the need to recognize apartheid in Palestine for all the very concrete and practical reasons I explained. So I think there's a way to bring everyone to the table and come up with a compromise in the negotiations to be able to get a robust definition that includes a greater swath of victims. I mean, just to say to one point that Max Marcus raised, which is, whenever we list groups, we start to leave people out, right? If we add gender and race, who are we leaving out? There's other groups we're leaving out from recognition of apartheid. So it would be better just to end the definition, where it is. But sometimes we also have to be realistic in what we can fight for. So if we can fight to at least include race and gender, we should do that. But we should always be sure in our talking points that we're not closing the door to including other groups and we're not compromising too fast.
Thank you, Lisa. So we have another question for you. So there's a question, and it says, this has come up in various meetings in the Global South. South Africa and Namibia apartheid is historical. Now with the Palestine, Israeli apartheid is highly disputed by not only Global North member states, but also some NGOs. Are people advocating for gender apartheid talking to Palestinian women? What is the view of Palestinian women on this question?
Well, I mean, like I said before, I think what we need to do is bring all stakeholders together to have a conversation. That if we're going to talk about the crime of apartheid, we need to bring in other actors, other groups that experience apartheid or might be experiencing acts that would amount to apartheid in their situations. And honestly, that's not limited to even the groups we talked about. If you look at UN reports, we've also talked about apartheid-like conditions that Rohingya experience in Myanmar. And there's certainly been other groups as well that have been examined by scholars as being in apartheid-like conditions. So I think it's a great question. I don't want to speak for what other groups think or feel on this call, but what I do want to encourage is that we bring all these stakeholders together so that we can have these conversations together. Artemis, you're on mute.
Thank you, Lisa. And I see also another question from Maxine Marcos. So Maxine asked that, may I ask whether we should perhaps also consider adding other grounds into the proposed definition? Do we risk leaving out other prospective victims of intersectional aspects of harm that may be beyond or include other grounds beyond gender and or race?
I mean, I couldn't agree with Max Marcus more. We should be having these conversations. In fact, when we advocated to remove the outdated definition of gender under gender persecution from the Crimes Against Humanity Treaty, we did have these conversations. And one of the things that we did was we said, well, you know, I'm a gender justice expert. That's my wheelhouse. That's what I know. But I worked with Madre, and Madre created a toolkit. And that toolkit talked about how civil society could intervene with the Draft Crimes Against Humanity Treaty. And it was sent to groups that work on racial justice issues, that work on disability issues, that work on indigenous rights. It went out to multiple groups that work on marginalized groups issues and said, look, our wheelhouse is gender, but we think that the categories for persecution shouldn't be limited to 7. It should include language. It should include disability. It should include indigenous status. It should include sexual orientation and gender identity. Even though that's covered under gender, it's important to be able to have categories that also highlight the diversity and the marginalization that groups feel acutely. So we made that call while we were really focused on removing the definition of gender. And you know what happened in that case is that a slew of special rapporteurs wrote a letter and called for the categories, the grounds under persecution to be expanded to include all these other groups that had been left out of the list of grounds. Now, that's great because that letter the special rapporteurs wrote, that becomes part of customary international law. We can cite to that letter when we're fighting for the rights of those marginalized groups. Unfortunately, the drafters of the treaty at that moment didn't include those groups, and they didn't expand the grounds that are protected from persecution. But they did remove the wonky, outdated definition of gender. So we at least, you know, we appreciated that.
Thank you so much, Lisa, for answering all the questions. We don't have any more questions. I don't see. Yes, we answered all the questions, Lisa. Thank you so much for that. I wanted to ask you, Lisa and Wendy, do you have any final remarks before closing the webinar?
Well, I will just say first, thank you to Madre and to you, Artemis and Wendy, for you know, organizing this event and asking me to come in to present on gender apartheid. It's an incredible moment we are in contemporary times and in history. And this is a moment where we could get codification for a broader swath of, for a crime that would recognize a broader swath of victims. And I think that's so important. Let's make sure we don't leave women out of gender apartheid or LGBTQI plus persons, that we don't leave out Palestinians from apartheid based on racial discrimination, and that we make sure that we're taking an intersectional approach and that we're looking at apartheid through that intersectional lens. So we're not leaving victims go through the gaps like Black, South African, and Namibian women and LGBTQI plus persons. This is our moment to codify change, and hopefully civil society will engage on this, and hopefully we'll be able to see redress by modernizing the definition of apartheid in the Draft Crimes Against Humanity Treaty. So thank you so much.
Thank you so much, Lisa. I see Wendy's hands. Over to you, Wendy.
Thank you, Optimus. Thank you, Lisa, for that comprehensive detailed presentation. You've given us a lot to think about and to read. And my one quick comment, and I really just want to really echo what Lisa has said around consulting and engaging and being in deliberate and intentional conversations with others in other contexts, people, women, LGBT people across contexts where the experience of apartheid is not just as in South Africa, and maybe it's historical, but where we are still living with the legacy of apartheid. These conversations are important. And then for the most part, and most importantly, in my view, I want to emphasize, and it has been stated already, but to put back on the table that with the ongoing impunity and deliberate denial of Israeli apartheid practices in Palestine, that any conversation around a definition of apartheid under international criminal law must be designed around being in conversations with Palestinians. And I like the idea that you've put on the table, Lisa, which is when we look at reparations and redress and justice for crimes committed in the Palestinian context, what we can get right in this moment is a definition that embraces and really takes into account apartheid policies and practices across Palestine. And this moment in the process of developing this treaty gives us that opportunity. And so let's all get going on the work. Thank you so much for doing this presentation.
Thank you so much, Wendy. So I think we can close the webinar. So thank you, everyone, for your thoughtful questions and engaging in the discussion. And also a special thanks to our wonderful speakers, Wendy Isaac and Professor Lisa Davis, for their powerful contribution today. This conversation has reminded us how vital it is that the emerging Crime Against Humanity Treaty reflects the full scope of apartheid as experienced in our world today. On behalf of Madrid, the Gender Persecution Observatory, and the Afghanistan LGBTIQ+ organization ALLO, thank you so much for joining us today. We hope this discussion continue to inspire collective advocacy and legal reform in pursuit of justice and equality for all. Before we close, please note that this webinar has been recorded. For those who were not able to watch the full session, a follow-up email will be sent with the recording link so you can revisit or share the discussion. Thank you so much again, and we wish you all a wonderful rest of your day. Thank you so much.